Bryan Kohberger, November 7th, 24, that would have been yesterday, had a hearing. Bryan and his defense team are fighting to strike the death penalty. So far, they've not succeeded, but this hearing has not been ruled on yet. His attorneys did score an early win in an Ada County courtroom on Thursday when a judge ruled that he would be allowed to appear in his street clothes at pretrial hearings. So Kohberger was wearing a blue shirt and a suit for his second appearance. The hearing focused on motions related to the death penalty, and Kohberger faces as most of you know, if he's convicted of the murders of the 4 college students, then they are seeking the death penalty. So his lawyer is trying to get a head start on it because it's very complicated. His murder trial isn't scheduled to begin until August 11th. But the hearing yesterday, the defense attorney Ann Taylor argued to Judge Stephen Hippler that Idaho is not currently capable of executing inmates on death row. What she means by that is they don't, because they do. They actually do lethal injection in addition to the firing squad. But she's saying ways to execute them is dehumanizing. So that was one of her arguments in the motion. He disagreed with her argument, saying that Idaho does have legal means, and then he began to tell her the firing squad lethal injection. Judge Hippler also noted that even if Kohberger is sentenced to death, it would be more than a decade before any execution would be carried out. Now, currently, there are 27 states who still exercise lethal injection and the death penalty. Basically, it's a form of punishment, is what they consider it, but for some, it's considered inhumane. And Ann Taylor referenced a prior case, the case of another Idaho inmate who was scheduled to be executed next week. So she brought that up in her defense, which is the Creech case, which was an inmate who had been sitting on death row for decades. Well, he goes to get executed the other day, and the medical staff were unable to establish an IV line, so they ended the injection. And even then, his lawyers have to file multiple motions to try to suspend the execution. So she used that as one of her defenses. Why is it important to strike the death penalty early on rather than later? Because it's such a tedious job trying to get eliminated and removed that it's better to get an early head start on that. The state argued the defense's arguments were too vague and should not be accepted. They haven't even suggested what a proper alternative would be, which, in my opinion, she's not going to, because she doesn't believe in the death penalty in general, as far as it's just all dehumanizing. Hippler stated that he would take those arguments into advisement and issue a decision later. The defense pleaded with the judge to allow testimony from Professor Eliza Cover, whose research has examined capital punishment and constitutional law. But he stated that it would not be relevant or helpful to the court to decide this issue. Kohberger's defense argued several other motions to strike the death penalty, citing grounds of arbitrariness. The Idaho law on aggravators is vague in violation of the defendant's Eighth Amendment. So, constitutionally, she is stating that the death penalty is in violation of his constitutional rights to cruel and unusual punishment. The defense cited their other issue and reason for removing the death penalty is they cited the jury as an issue. Okay, it goes to the point of why we are arguing all these rights. Okay, so when you're doing a death penalty case, it's unlike any other case. It's not like any other murder case or any other case that you're going to work. You have to have special qualified jury members and they're considered death penalty qualified jury members. And then there's it's going to be more difficult to convict because you're going to have to prove more because there's more at stake. So their death penalty cases are very strategic and very difficult. Taylor argued that if Kohberger went to trial at the initial date, he would have to give up his right to a fair and impartial jury and effective counsel, which is something he gave up whenever he agreed to the fast and speedy trial. The state simply argued that they chose that option. In Idaho, a case must be brought to trial within roughly 6 months of an indictment unless a defendant waives the right to a speedy trial. So the defense argued it is a conflict of constitutional rights, specifically Kohberger having to choose between effective assistance of counsel or a speedy trial. So they felt like they were more or less pushed and persuaded into doing this because they didn't want a speedy trial, because they felt like it would not be, they couldn't represent it properly. They wouldn't have enough effective time to collect all the evidence and properly process the case, and which they wouldn't have. So they feel like it isn't fair that they had to give up that constitutional right just because they simply chose not to do a fast and speedy trial. The defense also argued that it's not possible to properly carry out that legal process for a death penalty case that quickly, which is very reasonable. And then a lot of people, something that I know that several have messaged me and wanted to know more about, was the death penalty. So why is it harder to convict on a death penalty case? I'm gonna do this really quick. The eligibility criteria. When you're doing a death penalty case, the eligibility criteria for the death penalty varies across the jurisdictions, but often include factors such as like the nature of the crime, the presence of aggravating circumstances, and sometimes the defendant's criminal history. Those are all weighed into the considering factors. The phases of a death penalty trial are meticulously structured and involving jury selection. Like I said, you have to have a death penalty qualified jury, presentation of evidence, and when I say a death penalty qualified jury, included in that is a jury that is not against the death penalty. Very difficult. So you have your jury selection, has to be a whole process. Presentation of evidence is going to be different, and your legal arguments are going to be different. The guilt phase determines the defendant's culpability, while the penalty phase examines whether aggravating factors outweigh mitigating factors. So ultimately, deciding whether or not the death penalty is warranted, basically, is what that's all going to constitute. So convicting someone in a death penalty case is typically harder because your burden of proof is higher, your enhanced jury scrutiny, your requirement of aggravating factors, your increased judicial safeguards, and greater defense resources. You're going to have to up your experts and so forth. So it's very, very difficult, especially to make a conviction in a death penalty case.